Representative Angelos?
Here.
Representative Harrelson?
Here.
Representative Pendergraft?
Excused.
Representative Sherwood?
Excused.
Representative Smith?
Here.
Chairman Bear?
Here.
Mr. Chairman, you have a quorum.
All right, let's see, Representative Smith, would you lead us in a word of prayer? And Representative Angelos, would you lead us in the pledge?
Well, Father God, we just come before you today. We thank you that we are here and healthy and alert. And Lord, I just pray that you would just give us wisdom that comes divinely from you. Lord, we just ask this in Jesus' name. Amen.
Turning to public comment on Senate File 169, and I'd like to start with the room. Is there anyone in the room, and specifically legislators? We'll go back. Is there anything you'd like to add at this point, Representative Wharf?
Mr. Chairman, I'm just here to answer any questions.
Okay, all right. Representative Connolly, would you be interested in opining on Senate File 169?
No, thank you.
Okay, all right. I don't see anyone else. Is there anyone else in the room that would like to testify on 169? Okay, let's go to online. Ms. Childress, who do we have first? Let's start with Mr. Jones.
Oh, okay. Sorry, I picked someone else. All right, Mr. Jones, we'll start with Mark Jones.
Ms. Childress, I realize now that we have a county attorney. We'll probably go to that person next, then we'll finish up with the rest of the public comment. Mr. Jones, welcome to House Appropriations.
Thank you, Chairman Bear, and thank you, committee. My name is Mark Jones. Of course, I think I know everybody there. I'd be there with you today, but I broke my leg, so you have to testify by video. But I am a national director with Gun Owners of America. We represent about 2.5 million Americans and many thousands here in the state of Wyoming. I live in Johnson County, Wyoming. As most of you know, I'm usually there through the legislative session in person, and very interested in these bills, both from the perspective of GOA and as a citizen of Wyoming, and the way it impacts the rights of me and my family. A lot of talk about 196 has been centered around what GOA thinks. I've heard a lot of people say what yesterday in testimony, what other gun groups say, and I'd like to speak to that today from our own perspective. GOA has always supported the concept of having both a criminal and a civil cause of action in a Second Amendment Protection Act. And a Second Amendment Protection Act is essentially a concept that we've worked on around the country that makes it illegal for officials to infringe upon people's Second Amendment rights. And many people don't understand the difference in criminal and civil. In fact, many members of the legislature don't, I've learned over the years. And it's important that we understand that and understand what we've got, how we got here, and where we need to go. So in 2022, Wyoming passed Wyoming Statute 9-14-203, and that is the criminal SAPA. We worked with law enforcement around the state of Wyoming with members of both chambers to get that law in place. A lot of misinformation has been put out about that law. It's been called cover for rhinos. People have said nobody will ever enforce it. Many Wyoming prosecutors stepped up when that law passed in 2022 and said they would enforce it. And it was widely regarded at the time it passed as the nation's best criminal Second Amendment Protection Act. Is it perfect? No law is perfect, but it was a great step in the right direction. We've always been very pro-law enforcement. We believe the vast majority of law enforcement officials are honest citizens trying to protect the public. But there are cases, and you have people online that would like to testify today about when things go awry. There are cases where people's rights are infringed upon, and those are serious. And I hope you'll let those people testify today. But anyway, so the criminal SEPA was a great step for the state of Wyoming. And we have also always been committed to having a civil cause of action for citizens to use to go to civil court when their rights are violated, not to sue individual officers, but to sue departments. And this is a concept that's been established in a number of states. And the concept is a deterrent because it's a potential impact on the department's budgets, and it helps keep departments in line. And we have some departments that have been out of line. And again, you'll hear testimony to that today if you'll allow it. And the civil cause of action is necessary, and it's very important. And I hope everybody on that committee is listening. We need both a criminal and a civil cause of action in the state of Wyoming. We worked with legislators every year since 2022 to try to establish a civil cause of action. And for various reasons, because of composition of the legislature and various factors, those bills never made it to the point where this bill is today. So we fast forward to the introduction of 196 a few weeks ago, and quite honestly, when it was first introduced, we viewed it as a political stunt, as a very negative, because it proposed to repeal the criminal SEPA. And we came out immediately and said this bill's unacceptable. We put out notices. We do what we do, and we organized a grassroots outcry from the state of Wyoming. And the evidence of that is the fact that on February 3rd, bringers of the bill came to the Senate committee, and they proposed an amendment before the bill was even read to fix 196 and put the criminal penalties back in. That was because of the outcry from GOA about, hey, let's don't have a political stunt in Wyoming. If we want to have civil penalties, let's have civil penalties. But we're not going to repeal criminal SEPA. That was put back in the bill on February 3rd, right there in that building. And at that point, we had a bill we could work with. We had a bill that had some possibilities. Many people have been surprised that we've now shifted to supporting this bill, but we're more interested in doing what's right for the citizens of Wyoming than we are in playing political games, unlike a lot of people. This bill has potential. This bill needs 2 amendments. I've given those to Representative Harrelson, but it is something that can be worked with. This bill, there's 2 places in this bill where the definition of officer needs to be defined better. That's found, I think, in 7-2-101. There's a definition of officer that covers pretty much everybody that can be an officer, from game wardens to county and local. That needs to be inserted 2 places in the bill so there are no loopholes. And the bill needs a severability clause. Bills like this have been challenged in court across America. The Missouri bill was struck down by a circuit court because it had some flaws, and a severability clause will essentially protect other components of the bill should a small part of it be struck down in court. I don't anticipate that happening. This bill is with the amendments that were made in the Senate on February 3rd at our request, and with the amendments I proposed through Representative Harrelson. I do believe that this is a bill that advances Second Amendment rights in the state of Wyoming. I listened to the debate about this bill stopping task forces. I've had our attorneys review that very thoroughly. We do not believe this bill does that. This bill does not stop ICE immigration. This bill does not stop drug task forces. What this bill does is stops the enforcement of federal gun control. And to be clear, it puts the criminal penalty back in Wyoming statute, which has been there for 3 years, and it gives citizens of Wyoming a civil path to go to court and sue the department, not the officer, should their rights be infringed upon. We believe that overall, with the amendments that I've given to Representative Harrelson, this can be a good move for the state of Wyoming. And with that, I'll stand for any questions. and defer any more time I might have. I hope you'll allow Randy Kane and Noreen Scroggins to testify, because I think you have an example waiting to testify of people whose rights were infringed upon, and they're the kind of people that this law is designed to protect.
Mr. Jones, the House Appropriations Committee never restricts anybody's ability to testify here, so no need to worry about that.
No, Mr. Barrett, Chairman Barrett, and I did not mean to suggest that you did, sir. You've always been very fair. But there have been other committees in the history of my time in Wyoming where that has been a little bit different. So, but your point's well taken, sir.
Okay. Any questions for Mr. Jones? I'm going to start by asking Representative Harrelson to walk us through some of the things that are happening in this amendment while we have you here, Mr. Jones. So if there's questions that do come out of this amendment, we've got you here immediately. So Representative Harrelson, if you could just walk the committee and the public through what your amendment does. And Mr. Dorr, if you wouldn't, and Representative Wharf, if you guys wouldn't mind coming forward, I'd like to hear your opinion about this amendment.
Jackie, real quick, would you mind if I get a copy of that? I gave mine away. I did. It's a bad habit I have.
And do you gentlemen have a copy of this? Yes. Okay.
Thank you very much. Okay, Mr. Chairman?
Please, Representative
So we actually have, I've kind of combined two things. One, there was an amendment brought by the bringer of the bill that was a cleanup amendment that was caught by our staff that needed to be cleaned up. And so from lines 1 through 20 of this amendment, that was that original amendment brought by our Senate counterparts, the bringer of the bill. And what that does is it just aligns this section 1-39-104, the granting immunity from tort liability on contract and exemptions. And really, it's the same. It just cleans up some of the referral to the different subsections that were in there. So that's that first section of the amendment, and it takes and cleans that up. So if you look at it, after on page 2, line 16 through 23, deleting that, page 3, line 1 through 6, deleting that, and then reinserting this language. And that what that does is just, that's a cleanup amendment that was brought, that was found after it moved out of the upper chamber. Now, if we start on line 22 through 31, that is the amendment that we're talking about. And it's inserting on page 4, line 6, you're going to see that we are inserting the definition of a peace officer as defined in 7-2-101A 4. And really what we're doing here is just further describing. So it says nothing in this act shall limit or restrict a public officer as defined in 6-5-101A 5 or a peace officer as defined in 7-2-101 4 from providing assistance to federal authorities for purposes not specified or identified. So we're just adding in that second to make sure that that net catches peace officers. And then on page 4, line 15, there was an issue with a spelling where it says law enforcement agencies that employs, and it's not employs, it's employees. So we fixed that in line 25 of the amendment, fixed that spelling correction. And then on page 7, line 22, you see that we are doing the same. We are inserting peace officers defined in 7-2-101A 4. And that again is just to bring clarity for public officer or peace officer. And then on page 9, line 4, it brought in that spelling correction of on material aid shall not including, we bring that back to include. So that in essence is the amendment, Mr. Chairman, and if and would be open to questions and conversation.
Okay. Mr. Jones, is that a sufficient description of what this amendment does?
Mr. Chairman, I did not hear anything about the severability clause. And I do not have a copy of that First Amendment that Representative Harrelson described as a cleanup amendment brought by the bringers of the bill, but I trust that that doesn't impact the intent of the bill. But the main question would be regarding the severability clause.
Okay. Representative Harrelson?
Thank you, Mr. Chairman. So this page 9, line 8, we would insert section 3, Wyoming statute 9-14204, and it's created to read 9-14204, or severability clause. If any provision of this act or its application to an individual or circumstances held invalid, the invalidity does not affect other provisions or applications of this act, which can be given effect without the invalid provision of application to this and the provision of this act are severable. So that would be included in that. Thank you for that catch. I appreciate it.
Okay. Any questions for Mr. Jones or Representative Harrelson on this amendment? Seeing none, I'm going to go to Representative Wharf. Do you have any comments on this amendment? Actually, two amendments.
Thank you, Mr. Chairman and Representative Harrelson. Yeah, I think all of those amendments are good. I think they actually strengthen the bill and help add clarity, so I'm certain we can support that.
Okay. Mr. Dorr? No concerns. Okay, all right. All right, so we're going to address that when we get to the bill, working the bill, but I wanted to have that conversation. All right, thank you, Mr. Jones, for being here, and you gentlemen are released if you have something you need to do, but.
Thank you, Mr. Bear. Thank you, committee.
All right, Ms. Childress, would you please bring in the county attorney that we have online? Got that list here. You know, Mr. Jones, are you still online with us?
Yes, sir, I am, Mr. Chairman.
I had some questions written down here that I have been meaning to ask.
Okay.
So while I've still got you, I'm going to ask these questions. You mentioned that the Missouri law was struck down. We heard testimony on that yesterday. We've had, 9-14-203 for a couple of years now in effect. Has there been any action, legal action taken on that 9-14-203, either against it, or has the act been used to this point?
Mr. Chairman, to my knowledge, the 9-14-203 has not been used in Wyoming, and there has not been any legal challenges to it either. And so Missouri's in a different circuit, and that was a civil law. Of course, the current Wyoming law is a criminal law. So two very different laws and two very different federal circuits. No impact on Wyoming's current situation based on what happened in Missouri.
Okay. Thank you very much.
Thank you, Mr. Chairman.
And let's see, who are we bringing in now?
It's Joshua Stensaz.
Okay. Mr. Sensaz, thank you for coming here and testifying. Welcome to House Appropriations Committee. Please introduce yourself. Let us know who you're affiliated with and your opinion of Senate File 196.
Thank you, Chairman Bear. Thank you, committee members. I appreciate the time to speak on this. Tucker Ruby was intending to speak on this, and so were Dan Itzen, but Tucker's in trial and Dan's in court right now. I was also prepared to speak on this as well, and so I appreciate your time. The first thing. I also want to note that the County Attorneys Association is who I'm speaking on behalf of, and that's who those gentlemen would have spoke on behalf of. And we just wanted to go through a couple areas that we have some requests for some changes in. I think it should be noted on the front end that all the county attorneys that I'm aware of absolutely support the right and the idea of protecting the Second Amendment. What I would say with this is I'm going to lead off right where Alan Thompson was yesterday a little bit, talking about arrest warrants. And he talked about the fact when an officer pulls somebody over, they don't actually know if that warrants for a gun crime or not with ATF. The bill as it in its current form, and I don't have a specific line or amendment to this because I think it affects multiple areas. So I would just note that I think it's something that this committee needs to kind of view in an overall arching area and figure out where it's best to fit this in. But an officer won't know that that warrants a federal warrant for a gun crime. But even if the officer did, so let's say the officer actually knew that that warrant was an active warrant from ATF for a federal gun crime, and he's like, well, I'm not going to engage in this. The problem is there's actually a statute, 65115, that requires that officer to arrest on any criminal case where there's a warrant. And so you've actually placed an officer in an impossible position of he's going to violate a crime by arresting, or he's going to violate a crime by not arresting. And I think that's something that absolutely has to be addressed. So I would just ask this committee, and the reason I say it affects more than one area, so I'm not identifying a specific line, is I think that it can affect, various areas throughout this bill. So I would ask the committee to review that and figure out a way to not place an officer in an impossible position of, if they are arresting on an ATF warrant, they're violating this act and a criminal, they're subjecting their agency to a $50,000 penalty and criminal prosecution, or if they don't, they're still doing subjecting themselves to criminal prosecution. The next area that I'd like to talk about that the county attorney's office noted concerns over is on page 8. And I would note, I think there is some good language that was added in here as far as lawful seizure of a firearm, accessories or ammunition related to a violation of Wyoming law. I'm going to give you a couple of real world examples of law enforcement. There's been a couple cases like this that I'm aware of. We get a phone call from a spouse calling and indicating that she's afraid, has her kids in the bathroom, that her husband is intoxicated, has a gun out with him, is breaking stuff up in their house. And law enforcement, of course, responds to that because we want them to respond to that to protect our citizens. So when they arrive at the house, she has not indicated that he has threatened her with the gun, and he's smashing up his own property. There's no violation of law for smashing up your own property. It's also under Wyoming law, I can't find that there's any prohibition against being intoxicated and running around with a gun. And so law enforcement shows up to that scenario and they need to figure out whether she's okay or not. Well, the first thing that law enforcement's going to do is ask him to set his gun down, because it is a very tenuous situation and almost impossible to figure out what is going on until he sets that gun down. And under your definition, the definition that I see in this of the law-abiding citizen, he's a law-abiding citizen at that point. And so what I guess my concern with this is there's this interplay between, I appreciate the language being added in G(i), including the idea of investigation. The difficulty is then you're still looking back at a law-abiding citizen when I think you look at the term lawfully seizing a firearm. And you are seizing a firearm if you're asking them to set that thing down. So that scenario, I have the County Attorneys Association. There was a suggestion that in the definition of law-abiding, and this would be on page 8, line 18, that after the word firearm on page 18, it would be added, and is acting in a law-abiding manner. So this actually helps with certain scenarios. It doesn't even really help with one that I just gave, but it would help with another scenario I'm going to give you guys, and that would be the idea of a criminal entry. It's not against when we look at the provisions of this act, if somebody is breaking into a home to steal or to commit a felony therein, we have a burglary, and it's a specific intent crime. A gun becomes a portion of that crime. If they enter with a gun, then it's an ag burglary. The interesting part is, if you can't prove specific intent, you only, if you can't prove that they're doing that, the crime is criminal entry. Well, there's no charge associated with taking a firearm into somebody's home if I'm not there to commit a felony or a theft therein. So the only crime they've committed is a criminal entry. And so law enforcement could respond to somebody exiting a house with a firearm on them, order them to set that firearm down. And so I think it would be a question then, are they a law-abiding citizen? They, under this particular statute, I think there is concerns that they still would be a law-abiding citizen. And I do think we want our law enforcement to stop people breaking into houses who have guns. That would seem to be something that we could try to curtail. So I think the language that I noted in line 18 would actually help with that. I don't know that it helps with the domestic fully, and I think the committee might want to see that, because the domestic situation is actually much more common in law enforcement than many others. So that is that area. One of the other areas of concern, I'm going to give another example. And literally, Mr. Ruby's trying a case right now involving a DUI. And we end up with two individuals stepping out of a vehicle, and you have one of them, they're both intoxicated as far as I can tell, and one of them has a gun on them. Under the statute, this, once again, I think they would qualify as a law-abiding citizen. It wasn't the driver. So you have a passenger who's intoxicated with a gun on them. Law enforcement is trying to deal with the driver who is DUI. In this case that I'm speaking of, what law enforcement did is ask the person to set the gun in the back of the pickup bed while they were dealing with the case, because of the volatile nature of what was going on. And when you have even having a second person present during something like this, armed and intoxicated, I think that presents a pretty good officer safety issue. Once again, I think this would be a question of that person, under the definition of law-abiding citizen, that officer having them set the gun in the back of that truck. In this case, when the officer was done arresting the individual on the DUI, the driver, they literally handed the gun back to the intoxicated person, and they got to go on their way. But the idea of that qualifying as subjecting your agency to $50,000 worth of liability, this goes hand in hand with the next concern of the County Attorneys Association, and that would be the civil penalty portion. So if we look at page 5, line 7, page 5, line 7, if we are going to continue with these particular things, I guess my hope is that the idea of a judge, that if an officer had an officer safety issue and asked this person to put a gun in the back of their truck and then immediately gave it to him, that being a violation of this law would be mandatory, that agency is fined, or it has a civil penalty of $50,000. Well, we're taking away the court's discretion in that to say that officer was acting appropriately under the circumstances and facts he had in that case. And so you're taking away the court's discretion to find cases where a judge may say that officer was absolutely doing what I think was reasonable. However, he violated this law, and I think the agency should not be fined $50,000. And so taking away the ability to recognize the inadvertent nature of, there may be a violation of this that is very inadvertent. And there's a very good justification for that, the officer acting as the way he did. you're requiring the agency to pay $50,000 per violation. And the judge couldn't say, hey, we think in this case that the officer was acting appropriately. Perhaps he should have the agency should have a $500 fine. And so the proposal on this is that under on page 5, line 7, that the language in an amount of is struck, and you put language of up to $50,000. That way, when you have a judge who reviews a case on something like this DUI, they would have the ability to say, no, we don't think the agency should have to pay that much. Another area that,
Mr. Stensis,
yes, sir.
we have a question. Representative Harrelson.
Thank you, Mr. Chairman. So, Mr. Stensis, thank you for being here and testifying. On page 8, lines 6 through 8, as I was looking at this, nothing in this section shall be construed to preclude any investigation and lawful seizure of firearms.
Well,
If in that situation where you're at a DUI case or the other case you mentioned with a potential domestic violence, those are investigations, are they not?
Mr.
they are,
Stensis?
yes, they are, Mr. Harrelson. Thank you, Chairman. They are an investigation. The question I have is the play of the word lawful seizure of a firearm, because then I think you're going back to, in essence, if this very law says that a law-abiding citizen, so we don't have a definition of lawful seizure of a firearm. So we're going to look at the definition of law-abiding citizen to see who we can and can't seize firearms from. So I believe that language in GI was very important to add. 100%. My concern is that I don't know that lawful seizure of a firearm, how is that going to be defined in light of a law-abiding citizen, sir?
Representative Harrelson, follow up? Mr. Census, you mentioned, 65115, and I'm looking at that, but surely you know where the law enforcement gets their authority to seize that weapon in those examples that you provided. Where would that be?
Excuse me, sir, I'm sorry. What?
So you gave 2 examples of where law enforcement would need to, in your opinion, seize a firearm from a quote-unquote law-abiding citizen. So they have the authority to do that now. You're concerned about this bill restricting that authority. Where do they get that authority today?
So case law would talk about officer safety and the conduct that they can, where they can engage in this. So what I think this does, I don't think there's explicit authority. There's authority through officer safety. I don't think we have an explicit statute allowing them to do this. But the law has always recognized what an officer is permitted to do in a situation involving officer safety. And so I believe what this will do is affect their ability. I guess I feel like it could subject them, the way this is written, to criminal and civil penalties, because there is no direct statutory authority in Wyoming saying, hey, you can do this. But there would be direct statutory authority saying, hey, you can't do this.
So by your definition, it's case law that allows a law enforcement officer to perform that duty for their own safety, and that the jurisprudence currently supports that. So then this phrase that was brought up by Representative Harrelson of preclude any investigation and lawful seizure of firearms would then apply. A judge could easily see the statute in this bill, should it pass, would ensure that this bill did not allow a lawsuit or a criminal suit against a law enforcement agency or officer in those examples that you provided. Would you agree with that?
What I would agree with, sir, is that I think it's arguable. What I think would be better is to have something in this bill that allows for an officer during the course of investigation for officer safety purposes to request somebody's firearm, much like that DUI case, it was given right back. Much like the domestic violence, that firearm is going to be returned. And sir, I apologize. I probably have not researched this well enough, so I can't give you a very clear answer on exactly your question. Does the case law support the idea that the officer can act in that way during officer safety? I believe so, absolutely. But I don't know if there's anything else out there supporting that. So I apologize. I'm not. That may be a question for LSO.
So, Mr. Census, we interrupted your testimony. Did you have more that you wanted to say before we continue questioning?
I had one other, there were a couple other areas the county attorneys brought up in regard to this. And some of them are pretty simple. I think there was we were discussing the civil penalty, that a variance in the amount so that you can deal with cases that just because it gives the court discretion to recognize a severe case where they give the maximum and a case where it's minimal. The other portion of that, there was a request for the term injured party on page 5 and interested party on page 5 as well. One is on line 2 and one is on line 14. And the idea of what is an interested party, is that a civil attorney who recognizes that they want to be interested in this because there's attorney fees associated with it? That would cause me some interest if I was looking to make some money, I guess, in that regard. So I think that the idea of the interested party, opening it up beyond the people that are actually injured, generally, I'm not a civil attorney, but generally speaking, the idea is if you've injured somebody, you're liable to them. And law enforcement already is liable to somebody if they injure them under a potential 1983 action. So I would just ask, the request was that the injured party the injured party be included, the interested party be excluded, and the idea that, or defined to some narrow group that in regard to who is appropriate for this, not just leaving it broad. So that would be.
Mr. Census, since you're on this issue, do judges not already determine before a lawsuit can proceed whether a party is interested or has standing?
They do, and I wish I'd have pulled this case this morning. There's a case recently in the last year where they said, in essence, law enforcement has a duty to every citizen. Generally, under so I think there's a case out there that's gonna extend this much broader than you think. And I apologize. I can find that case and email it to you folks later. But that case opened up the liability of law enforcement, in essence, to every citizen. And in essence, saying every citizen has an interest. And so between that case and that interested party language, I can't tell you how that interplay will actually go. Like I said, I am not a civil attorney. It might be best to speak to a civil attorney on this issue. But the idea of keeping the injured party is always relevant. If you've injured somebody, they absolutely should get a recovery. I think there is a concern over opening that up. So that's the recommendation. I can get that case for the court, but I apologize. I literally ran out of time this morning. I thought about this one coming up and I didn't grab that case, so I apologize.
Well, Mr. Census, we've had to change our schedule a couple of times, so I won't hold that against you. But when it comes to this case that you've brought up, first of all, what is the jurisdiction that this case is in, that you're talking about law enforcement having a responsibility to all citizens?
It's a case out of, I think it was out of Teton County, had to do with seizure of marijuana plants, but they were, the THC level was not at the level where it would make it a crime. And And what happened is the agent involved had actually called the state to confirm with the state and see if they were a registered grow as far as a hemp grow. Did not come back as a registered hemp grow. So then he felt like he had the basis to go forward and try to figure out what these plants were. He did go forward with that. And the court said, in essence, no, I mean, this individual could sue, but the idea that it opened it up to folks beyond just the injured party. And I apologize. I will try to forward that case to the committee.
So one follow-up question on that, Mr. Census. Is there, in your mind, is there any reason why law enforcement shouldn't be responsible to all citizens?
What I would say is, I think law enforcement already has an obligation to every citizen to protect and serve. As far as civil liability, you're extending it beyond, you're opening this up beyond the injured person, which, once again, I'm not a civil attorney, but generally speaking, if somebody who was arrested, they would have a right to sue if that was a wrongful arrest. But now, then you could file a lawsuit, their employer could file a lawsuit. And, their cousins who didn't have them at their family reunion if you keep opening that up, and I'm giving a kind of a ridiculous example, but if you have liability extending to every citizen, regardless of injury, that is a concern. And the idea of just maybe defining what an interested party, and like you said, the court will find out, determine what an interested party is, but I do think there's a case out there that does cause some concern when you're opening it up like this. I absolutely think that every injured party should have the opportunity for redress.
Okay. Questions for Mr. Census? Mr. Census, don't you think it's every citizen's responsibility to ensure that the Constitution is upheld by every peace officer, every elected official that swears an oath to the Constitution?
Yes, sir. Yes, Chairman Bear. Actually, that is one thing that I do strongly believe in, the aspect of, when I look at something like this, I notice that it is focused at the executive branch. And in that aspect, sir, I actually think that there should be redress for any constitutional violation. And so I think our constitutional rights really do matter. And in that regard, I truly believe if we are going to apply this kind of standard of constitutional protection, I think it should apply to all three branches. And I don't know that that's going to happen, but from the idea of, if the legislature passes a law that's unconstitutional and violates people's rights, the people's rights it violates, those are the people that should have redress with the legislature. I don't think you guys are going to pass a law that says you can sue us and we have to do $50,000 for each time. But if you were to say that, by example, I'm going to give a general example. If you passed a law that affected stock growers that was unconstitutional, the stock growers should be able to come back at the legislature. And now I'm using it as a hypothetical, if the legislature would pass a law similar to this for unconstitutional violations. It wouldn't mean that everybody else, just because I'm not if I'm a stock grower, I should be able to come back at the legislature. But if I'm a garbage man, doesn't mean I should be able to sue the legislature if you were going to pass a similar law on this, or on the judiciary. And so I actually do believe this. I believe that the same liability should apply to all three branches of government, and in that regard, because we're creating protections, but we're doing it against, in essence, one branch of government. So that would be my comment, sir.
Mr. Census, I couldn't agree with you more that all three branches should be held to the same account when it comes to the Constitution. But we already have a methodology for citizens and the third branch, the judiciary, to take up actions by the legislature and strike them down should they be unconstitutional. We do not have a good method to hold the executive accountable for enforcement, which is their responsibility. And I think that's where this bill really comes into play, is trying to give the citizenry a methodology to hold the executive accountable where, you know, there wouldn't otherwise be any accountability. So with that, I appreciate your comments. Appreciate you being here. Okay.
Thank you. Thank you for your time.
We're gonna do, Ms. Childress, we're gonna bring in Noreen Scroggin. And then lastly, we'll get to Mr. Carmichael unless there's someone else that has joined us.
Mr. Carmichael is not online, but
Okay.
I just promoted Noreen Scroggin.
Very good, thank you.
Ms. Scroggin, if you could, there you go.
Okay, am I there?
Yes, Ms. Scroggin, we can't see you, but maybe you can uncover your video, so we'd love to see your
Okay.
bright and shiny face today.
Do that.
And welcome to House Appropriations.
Okay, I am trying to do that. I'm just wondering what I need to push to do that.
From our perspective, it looks like a big thumb over your camera.
Oh, I wonder why. Wonder where my, okay, let me. Wow. I thought I had this all together.
That's okay, we're patiently waiting.
Well, let's see if this does something. Oh, that's not what I want.
Ms. Scroggin, your testimony is very important to us, so if you can't get it, don't worry about it. We'll move forward. We'd love to see you, but if we can't do that, we'll go ahead and listen to you.
I don't want to leave it. Okay. Okay, well, I wish you could see me, because I have next to me Randy Kane. And we have, it goes back to back in June of 2023, there was a restoration of rights given to by Governor Gordon that those that have served their 5 years or more, and what I'm reading is that the completion of sentence, including applicable periods of probation. This was all made out by Governor Gordon, and the very bottom part of it says, this includes convictions in the state of Wyoming, other states, as well as a federal conviction. Because Randy was convicted in a federal court. And so then I called down to the correction facility there in Cheyenne, the Department of Corrections, and I talked to a Dawn Sides. And I asked her if this is what was going on. And she said, yes. She said Randy would be acceptable to get it, according to Governor Gordon, because he had completed everything. And the only thing that he could not do was buy a gun. So I said, no problem. So we filled the paperwork out. And then on the August, was that date on there? August 29th, we received a letter from the correction and a certificate for Randy to have his rights back and he could have firearms. And that was just awesome because it was what he'd been hoping for a long time. This happened back in 2003. And so he continued on, and then November 21st of 2023, that morning, we had a raid by the ATF. They came to our door pounding on it, and By the time I got to the door, Randy had been taken out, handcuffed in his underwear. And there was a gentleman there that said to me, come out, ma'am. And I go, I kind of lost I was kind of yelling and going, what is going on? And he says, ma'am, if you don't come out, I'm going to come in and pull you out. So I did go out, and they handcuffed me and put me in the back of a official vehicle, and they put Randy in the front. And I'm asking Randy, what's going on? And he says, I don't know. And there was a local deputy over by the driver's side, and he told us to quit talking to each other. So they moved Randy to another vehicle. So during all this process, Crystal from ATF asked me, I said, what's going on? And she says, I'll tell you in a little while. Okay. There was vehicles from Campbell County. There was vehicles from Johnson County there. Our local sheriff's department was there. And when they came to the door, they were dressed like a militia. They had body armor, the helmets, guns. They had a drone. They had a dog. And going, what's going on? And they eventually told Randy they had a search warrant and for the house and him and his vehicle. And we still didn't understand why. And they said, because he was Randy, you want to tell them?
A felon.
A felon. And he didn't have the rights for the guns. And eventually Crystal came back to me, and I wanted to go into the house to go to the bathroom. So she'd come in and she let me go. And she says, well, do you know what ATF is? And I said, no, kinda. And she says, well, we're here because Randy is a felon and he's got guns. And I said, wait a minute, he has a certificate, restoration of rights from Governor Gordon. And she said, well, we don't accept the state. And I'm going, what? And I says, it's in there on the thing. Well, they decided, they went through our home and they broke a few things and they left stuff around. And the other officers were still there from locally from our sheriff's department. And at one time she wanted to know about getting in Randy's safe. And I said, well, I says, it's very tricky. And I says, he really can't do it. So they proceeded to, I was in the handcuffs for a little over 3 hours. And Randy went down. He could not open the safe. ATF couldn't open the safe. And he told them to come and get me. Well, they didn't. And there was a local individual, Fielding, that said he was down there and he was kind of assisting with a local department, sheriff's department, and so then he all of a sudden comes back dressed in his fire department garb with the jaws of life and cut the safe open. And it's like, I'm just kind of surprised, where does this individual step in? And it's a volunteer fire department. Randy belonged to it. And they knew Randy. And I just don't understand why all this happened. It was like a militia attacking us. And for what? And they finally, they left. And when she let me go, she said, well, you can come back in a few hours or somebody will call you. And then Randy eventually called me and said they had all left. Nobody was arrested, nothing. But the whole thing is, when I called, after this all happened, I called Governor Gordon's office. And the lady I talked to said that, well, you're just going to have to call the correction officer. I said, Governor Gordon, he's the one that was on our emails, everything, promoting, saying it was legal. Randy could get his rights back. And she said, we're just going to have to call the corrections. So then I called back to corrections again, and I talked again to Dawn Sides. And I said, what's going on? And she said, well, the federal doesn't recognize it. And I go, well, And she said ATF is going to be mailing all the individuals that were given the certificate warning saying that federal government did not recognize it. And I said, well, what about Randy? I says, he was raided. And she said, her response, you have to get a lawyer. And again, it's like, why couldn't have the sheriff's department, they all knew that he had gotten it. It was a letter saying all these people had been notified that Randy had gotten his rights back. Why couldn't the sheriff and another individual contact Randy either by a letter or by coming to the home and saying, Randy, you can't have the guns, it's not recognized, instead of this blown out. I mean, it was devastating. I mean, to be hauled out and put in handcuffs. I don't know if Randy would like to add something to this.
Well, I mean, it was just kind of crazy. I mean, being 5 hours in back of an outfit, handcuffed, you know, and finally when they let me get out, I said, these handcuffs are way too tight. My hands are like purple sitting on them for that long. And then they came back with, where's the bombs and grenades? I go, what? Bombs and grenades? I said, what are you talking about? I'm not a malicious person, you know, and they're pretty avid about bombs and grenades. And I don't know where they came up with that. And they kept on asking Noreen the same question, I guess. And after all said and done, when they unhandcuffed me, I remember Crystal going, you got a beautiful home, beautiful place. Maybe this is your wake up call. I go, what? I mean, between the rubber gloves all over the house, just like there was no respect for them going through things. They didn't put the rubber gloves in garbage can. They just flung them off wherever they felt desire, and clips from the guns sporadically laying around the house. I mean, there was no,
It was a nightmare.
it was a nightmare.
But the state here, there was a lot of people involved here that were from the state of Wyoming that were showed up to, basically, they say they were to assist. There was even a individual from the office of the Attorney General. And I mean, the local was responsible for opening the safe.
I even went to the chief after all this happened at the volunteer fire department and asked him, I said, here's my certificate that the state of Wyoming gave me. I don't understand why they have this big raid. President of the fire board, which is Lonnie Wright, and told him, he goes, I can't believe that they'd done anything like that, especially you're a member. We don't do stuff like that. We don't open up safes like that. So it's just crazy that nobody wants to be accountable for anything. It's just, I don't understand why all this happened when they're going to give a letter to everybody else. They could have handled it so much different. I mean, I wish that this never happens to anybody else in the state of Wyoming. It's beyond what you could imagine. I mean, there was so many people here that, it's just people in the subdivision, they didn't know what was going on. They just thought, man, that's unreal that something like this could ever happen.
So, Mr. Chairman, that's kind of, we could probably go into a lot more detail on everything, but it's just a lot of local state people were involved with this.
Ms. Scroggins, thank you very much for being here. And I want to say, that I am very sorry that the state has put you in this situation. I know that we have some responsibility for having passed a law that allowed the governor to send that letter to you. I know I personally voted against that. I don't know that I really foresaw all the problems with it, but I did see problems. And we passed it anyway, and that's the way this body works. Sometimes we do good work, sometimes it creates unintended consequences, and clearly your situation is one of those. But I do have some questions, and the body, this committee may have other questions. So my first question is, can you just share with us what was the original infraction that led to the conviction, the felony conviction for Randy?
It was math back in 2003,
2003 is when that, yeah.
2003.
Okay. And I assume he served that sentence
Correct, yes.
to completion? When was that completed?
That have been 2003 again.
2000. It was in basically 2000. He got off early from jail sentence, and then he got off early on probation. And
It was like 10 years or whatever.
it was like 2006, 7.
Yeah,
The complete sentence was around 2007, because I met Randy in like 2007, and it was shortly after that.
Okay. When you were raided and your firearms were taken away, were those firearms belonging to Randy or to you?
Majority of them were Randy. I think I had 6 of them.
Okay.
They
And
did look into my safe. I gave them I told them where my combination was hid, but they didn't take any of the guns from my safe. But I've since then moved them all out of the house.
And so you still have possession of all your firearms, and I assume Randy does not have possession of any of
No, I have the
firearms.
majority of mine, but Randy doesn't.
Okay. And during the raid, were there any other criminal charges besides the possession of firearms for a federal felony?
Not for federal, was there?
no. Like, what do you mean?
Were there any charges brought that had nothing to do with firearms?
Well, I mean, what do you mean the far? They did find a small amount of meth that was in the safe, and at first I told them I didn't know how that all came about, but anyway, I just said that really I don't know anything about it, but I said I did claim that, yeah, I guess it's mine if you found it in there. I don't know, remember even it being in there or whatever, but there was a lot of people that were going around in the house. I just assumed took responsibility for it, and they gave me a misdemeanor charge on it, if that's what you're referring to.
Yeah, I think you answered my question. Committee, do you have any questions for Ms. Scroggins? Representative Haroldson.
Thank you, Mr. Chairman. More of a statement. Thank you for your testimony, guys. And again, I will echo the sentiments of the good chairman that this should have never happened. Yesterday on Committee of the Whole in Second House, we did bring in a bill that will protect people in the future and cleans up the restoration of rights bill. So basically, obviously, it doesn't fix the past, but it will lead us into the future, making sure that we don't put other people into your guys' situations. So definitely feel that that's the least that the legislature can do. It obviously it should have caught that in the first go around, but we are working on making sure that that doesn't take place in the future.
Thank you.
Thanks.
Ms. Scroggins, I want to just inform you and the public that there is a bill in process. It's going to be on second reading in the House. It's Senate File Number 9 that we do hope will avoid this problem in the future. So hopefully we've got a correction coming. And again, I apologize that you got caught up in this. I appreciate your testimony, especially about Campbell County, Johnson County, and Sheridan County officers being involved with that enforcement of federal gun laws. So thank you very much. We appreciate your testimony.
Thank you, Mr. Chairman.
So let's bring in the last one we have is Mr. Carmichael, please.
Mr. Carmichael, if you could unmute, turn on your video.
Hello, can you hear me?
We can. Can you get your camera on for us, please?
I'm really trying. I'm sorry. I was all prepared for this, had prepared statements, but thought it was going to be afternoon recess. Can you see me now?
We can, and we appreciate you turning your camera on and being here. We apologize that we had some last minute schedule changes here, but we do appreciate you making the effort to be here.
Well,
Please introduce yourself to the committee and to the public.
Okay, yes, thank you. My name is Jeff Carmichael. I live in Johnson County. And as I said, I had prepared statements, but I'm going to have to wing it now. So I apologize for that.
Mr. Carmichael, no apology necessary. We're just happy to have you here and just to hear your thoughts on Senate File 169, or 196, I apologize. Second Amendment Preservation Act amendments.
Yes, sir. And may I first say that I'm very grateful, appreciative of the opportunity to testify. So I just caught some of the tail end of the previous testimony there about what happened up in Sheridan. Did not catch all of it. And as I said, I don't have my prepared statements, but what I want to say is I think that we need to get back and remember how SEPA came about. And it was in the midst of an aggressive liberal administration attacking our Second Amendment rights at every turn. And one of the ways that they did that is through, at that time, red flag law legislation. That I believe is entirely unconstitutional and I'm very opposed to. But sadly, some sheriffs in Wyoming, I'll leave it at that, were in support of red flag legislation. And that combined with the never-ending attempts from the administration and the left and the gun control crowd to constantly come after my Second Amendment rights is what led the people of Wyoming to ask for and press for a strong SEPA bill protecting our rights. I've heard a lot yesterday from law enforcement about how this bill might keep them from being a part of a task force and I'm sorry, I don't have my notes. I'm really frustrated and, if you'll forgive me, sick of every time there is legislation to try to protect the Second Amendment, we never talk about what has happened, what is happening going on that we're trying to protect our rights against. We never talk about that. For example, what happened to Sheridan, to the previous people that testified there, or school shootings or anything like that. We don't talk about what has and is happening. We talk about, oh, well, what if this might happen? What if? Oh, what if? And as far as law enforcement goes, and I know that I'm just making the target on my back bigger right now here in my own hometown. But as far as law enforcement goes, I think that the sheriffs in Wyoming's first obligation is to the citizens of Wyoming. It's not to the federal government. It's not to get on a task force. It's not to do any of these other things that they're so concerned they might not be able to do if this bill passes. And as I said, I know full well what I'm doing right now, and I'm glad for the opportunity to do it. So I would just really encourage Mr. Chairman, you and the committee to consider why we have a SAPA bill, where it came from, what brought it about, and not get too caught up in the what ifs and the maybes. Think about more about what has happened and what's going to happen in the future. I don't think any of us are naive enough to think that the Biden administration was the last administration that's ever going to try to take our gun rights away. And I'm happy to answer any questions. I'll try not to waste any more of your time.
No time wasted here, Mr. Carmichael. We appreciate hearing your testimony. Questions for Mr. Carmichael? Okay. Mr. Carmichael, I just would like to drill down just a little bit as to the need for a Second Amendment Preservation Act. It seems to me pretty clear, both in the Wyoming Constitution and the United States Constitution, exactly, what our rights are in regards to possession and of firearms and ammunition, and our right to exercise that ownership. And so I'm just curious, from your perspective, how did we get here? How did we end up in a position where we have administrations, in your opinion, and probably mine as well, not enforcing the Constitution the way it was written?
How much time do you have?
About 10 minutes.
Excuse me. I don't know. We have been under attack in this country from the left, and I'm sorry if that's overtly political. I'm kind of an overt kind of guy. The Second Amendment is clear. The Constitution is clear, and yet it's challenged. And I hear people say, "Well, that's not written in stone," and it's a living document and all this stuff. I don't know how we got to this point. Challenges and questions and people who refuse to acknowledge our Constitution and the Second Amendment have been legitimized for so long that now people kind of accept it. I don't know how it is, but I know that we got where we are at right now because of actual actions against people who live under the US laws and the US Constitution and are protected by the Second Amendment, but we're not protected by the Second Amendment because ATF or whoever is absolutely out of control. And I'm sorry that I'm not more prepared for this. I actually was. But your question, I don't really know how to answer it. It's such a I just
It's a
can't, I
very,
don't know.
Mr. Carmichael,
Yes,
I'm
sir.
sorry to interrupt you. It's a very broad question, so I'm going to narrow it down a little bit. Why do you believe the Second Amendment exists?
The Second Amendment exists to protect my right to defend myself and my family, specifically against an overreaching federal government and government. It's not to protect my hunting rights or my hobby rights or anything like that. It's to allow me the ability to defend myself against a tyrannical government.
Thank you.
Okay.
Yeah, that was real clear, and we appreciate that. Okay. Any further questions for Mr. Carmichael? Representative Sherwood.
Thank you, Mr. Carmichael. Thank you so much for taking time to share your thoughts and opinions with us, even when, sometimes what we feel that we say could be controversial or misconstrued. So I just wanted to honor that you are here with us today. I appreciate your feedback. And kind of tongue in cheek here, but I just wanted to say, as a member of the token left on this committee, I want to let people know that I'm not here to take away anybody's guns because I have enough of my own. Thank you.
I believe the good representative has lost track of how many she actually has, so she's in good company here.
Well, with all due respect, I've been involved in a couple of different Second Amendment. I'm sorry, Mr. Chairman, I don't know how to address you correctly.
Well, you're doing fine. Thank you.
May I respond?
Yes, please do.
Okay. With all due respect, Representative Sherwood, as I've said, I've been involved in a couple of 2 or 3 different Second Amendment pieces of legislation here lately, and I think virtually every opposing testimony has always said, "Oh, I believe in the Second Amendment. I have guns and I really believe in the Second Amendment." And then they go on to blatantly challenge what the Second Amendment clearly stands for. And I appreciate the fact that you have guns, and I think everybody should have guns. And I don't mean to sound like I'm attacking you. I hope that I'm not coming across that way. Like I said, I'm kind of overt sometimes, I guess. So any more, and I'm ready for any more questions.
All right. Thank you, Mr. Carmichael. I think we're all done. We appreciate you being here. Appreciate you making this effort to share with us your thoughts on Senate File 196.
Yes.
All right. Ms. Childress, do we have anyone else online? All right. Is there anyone in the room that would like to testify on this bill? Seeing none, we're going to close public testimony on Senate File 196. Committee, what's your pleasure? Move to pass by Representative Haroldson, seconded by Representative Smith. Okay, we'll work the bill. Page 1.
Mr. Chairman,
Representative Haroldson.
if it's good with you, I'm going to insert that, that First Amendment, because it starts on page 1, line 4, and goes pretty much through the whole entire bill, but would like to insert this one, which addresses the cleanup language on page 2, line 16 through page 3, line 6, and reinserts, and then addresses the peace officer as defined in 72101 on page 4, 6, as well as page 722, and then has those two grammatical corrections or spelling corrections on page 4, line 15, as well as page 9, line 4.
Okay, this was described to us before a couple of members made it. Is there anybody in the committee that needs more explanation on this amendment? Okay, seeing none, do I have a second on the amendment? Seconded by Representative Smith. Any discussion on the amendment? Seeing none, all those in favor of the Haroldson amendment doing these corrections, say aye.
Aye.
All those opposed, no. All right, carries. All right. Still on page 1. Page 2.
And Mr. Chairman, I'll bring that severability clause in at the right time.
Thank you, Representative Haroldson.
Thank
Page 2. Page 3. Representative Angelos.
Thank you, Mr. Chairman. I'd like to add the word solely on line 17 after the word funds. So it says, or any federal funds or other source of funds solely. So after the second funds, we should say solely to enforce.
Okay. All right. Seconded by Representative Smith. Discussion on the amendment. I'd like to say something on this amendment before we go to a vote. You know, I want to be very careful with this bill that we do not affect the intent of the bill. I think it's very clear the intent of the bill is to prohibit law enforcement in the state of Wyoming from enforcing federal gun laws, period. And I think the word solely on page 4 and elsewhere throughout the bill effectuates that. So I want to be very careful to maintain that. This here, I believe, is an effort to avoid the chilling effect that may be there for law enforcement joining task force with the federal government. And I think this is probably very workable for law enforcement. We got that testimony yesterday. I think this is a good amendment brought by Representative Angelos. So those are my thoughts on it. Anyone else want to add some discussion to this amendment? Okay, I think we had that seconded by Representative Smith, didn't we? Okay. Seeing no further discussion.
Mr. Chairman.
All those, Representative Haroldson.
Thank you, Mr. Chairman. Just so with us leaving solely on page 4, line 2, but adding it in on page 3, line 17, maybe, I mean, I just want to maybe get a head shake or a clarification that aligns with kind of that, it's maybe coming kind of somewhere in the middle, or we're still protecting from it being that effect, but at the same time, maybe for law enforcement, I mean, I'm getting no's and yeses, depends on who it is. Okay, I just was wondering what the heart was on that. Thank you.
Okay. Further discussion, seeing none. All those in favor of the Angelos amendment, say aye. Aye. All those opposed, no.
No.
Okay, that carries. Okay, still on page 3. Page 4. Page 5. Page 6. Representative Sherwood.
Thank you. Sorry, slow on the uptake here. On page 5, I had this flagged, and then I see that there's some language floating around here on lines 14, page 5. I'd like to suggest an amendment that would delete an interested party and then insert a law-abiding citizen aggrieved by a violation of this act. I think that tightens the guardrails on who can bring suit.
Okay, you've heard the amendment. Do I have a second? Seconded by Angelos. Discussion on the amendment. I'm going to opine here. I'm going to resist this amendment. And because I think this is something that every citizen has a responsibility to. I think the last testimony where we heard Mr. Carmichael speaking, I think every citizen has a responsibility to hold the executive accountable to the Second Amendment. I think he struggled to answer how we got here. I would say how we got here is too many people who understand what the Second Amendment stands for, what its why it's in the Constitution, the Bill of Rights, have stood by while those who don't see a problem with restricting our rights have done so. So I think it's important that it's a very broad opportunity to take what this bill allows and use that to hold the executive accountable. Do I believe that our executive is egregiously hurting the Second Amendment in this state? No, I think most of their hearts are in the right place. But just like we, a couple of years ago, passed a bill that led to the testimony we heard today, unintended consequences, I think that enforcement sometimes leads to unintended consequences. And the public needs to be able to clearly stand up and say, no, this is wrong. And I think that this amendment is egregious to that. So on and against the amendment. Representative Sherwood.
Mr. Chairman, I appreciate hearing that, that it is all of our right and duty to uphold our Constitution and Bill of Rights. I just feel like the conversation would be more meaningful and more purposeful and more directed if this bill focused on those who had standing, so that we weren't talking about theoreticals, we were talking about actual things that have happened and will happen.
Further comments on the amendment? Okay, seeing none, all those in favor of Representative Sherwood's amendment, say aye. Aye. All those opposed, no? No. Okay, that is defeated. Page 5. Page 6. Representative Angelos.
Thank you, Mr. Chairman. I have a couple of them here. So line 17, after ammunition, I'd like to add, and is acting in a law-abiding manner, according to our testimony that we heard. I want to add the same, and is acting in a law-abiding manner on line 23, after the word ammunition. And there will be a third place, but let's see if we can, I could go to that, but we can wait till we get to that page.
Second.
Seconded by Sherwood. Let me try to read that in. Enforces attempts to enforce or participate in
Line
any manner
17,
in an
line
enforcement
23.
or implementation of federal act.
Mr. Chairman.
Representative Harrelson.
Thank you, Mr. Chairman. So if people are being law-abiding, they're being law-abiding. If they're not being law-abiding, they're not being law-abiding. So when we say a law-abiding manner, I think, first of all, it's a redundancy. Second of all, I question the fact that, are we opening up an area to sit there and say, well, I didn't think that looked law-abiding to me. So the context we had was someone who was intoxicated and had a firearm on them. That's not, we heard testimony that was not law-abiding. And so really, are we trying to put a net out there to catch people that shouldn't be caught? Or do we need to change our statutes to make it where we catch people that should be caught, type of deal? And so I just am a little concerned about acting in a law-abiding manner being put in there, and are we opening up the door to sit there and go, well, I didn't feel that was law-abiding, or are we aligning into statute? And if that's the case, if they're not law-abiding, then we already have Wyoming statute that gives us the ability to address that. So I don't know if the bringer could just give me kind of their heart on why this is a need. When I heard the testimony, I did not feel that it was a necessary change.
Before you respond, Representative Angelos, I think there's an issue with how you're applying this. So the subject of this paragraph I and II is the agency or the officer that enforces. So if we look at the verbs here, we're talking about enforces, attempts to enforce, participates in the implementation of any federal act. So if you add the words in a law-abiding manner, you're adding those words to the officer that's enforcing. So I think you'd have to, if you wanted to add those words, I think you'd have to apply it to a law-abiding citizen that's acting in a law-abiding manner. So just to clarify, I don't think your amendment right now is quite complete, or does.
I'll retract my motion.
Okay, all right. Still on page 6. Page 7. Page 8. And page 9.
Mr. Chairman?
I'm going to go with Representative Angelos first here.
Thank you, Mr. Chairman. Okay, let's make this motion again. Line 18,
What page?
sorry, 8, page 8,
Back-
line 18.
Back to page 8?
Yep,
Okay, line 18.
after firearm. I would like to add the phrase is acting in a law-abiding manner. And we'll probably have the same discussion, but that's where I'd like to add that.
All right, do I have a second on that motion by Angelos on page 8? Seconded by Sherwood. Discussion on the amendment. Representative Pendergraft.
Thank you, Mr. Chairman. That particular phrase, to me, is just far too ambiguous. What does it mean? And I would be a no.
Okay. Representative Angelos.
Thank you, Mr. Chairman. Just hearing from testimony, we don't have anything in statute, and I think we do need to address that to protect our officers, just to make sure that they understand. It's very clear that they can't have somebody set a weapon down in the case of a DUI or something with a weapon, because that's obviously law-abiding. But I think just having some clarity right now, that's why I would make that motion. So they have clarity now of what they can or can't do until we can get the statute changed. We can always come back and amend it. So that would be my motion.
Representative Harrelson.
Thank you, Mr. Chairman. So I think that 6 through 8 on page 8, precluding any investigation of lawful seizure of firearms, we have the ability, we're giving that opportunity, and I think that we have an understanding that in the situation where you're stopping to investigate a DUI in that case, or stopping to investigate a domestic violence case in that case, we are at a point where we're giving them the leeway to say, hey, you are investigating, you're not seizing and removing long-term. This is, hey, we're investigating a case, we don't know what we're up against. Sir, I need you to put that firearm down right now while we're investigating this case. They're protected here for that. And that is the purview of the law officer. When we sit there and say, when acting in a law-abiding manner, then it almost goes back to intent. We're deciding intent in this case. And I think when we started deciding intent, that's a dangerous place to go. Where we can sit there and say, law-abiding citizen. Well, we've got laws, and if they don't break them, they're law-abiding. If they do break them, they're not law-abiding. It's black and white. When we sit there and say, hey, we've got an investigation, and that's, I mean, we know when we're investigating, right? You get the phone call, you and a law officer pull someone over. I just think when acting in a law-abiding manner, if we start, it goes back to that thought police conversation we've had on the floor and in this chamber before. I just think that it's not going to serve us as we intend, and I hear the good bringer's heart, and I don't disagree with the heart of that. I just don't think this is probably the direction we want to make it happen. That's just my opinion.
Okay. Further discussion on the amendment? I'm going to opine here. If I were doing this, Representative Angelos, I would not put this in the definition of who a law-abiding citizen is, because this defines very clearly, and it is used in the bill, Representative Harrelson, already. So I don't know that, further defining what activity might be going on while during enforcement is entirely out of line. I understand your interpretation of page 8, line 6 through 8, and I think it's your interpretation is accurate. We do have a carve-out here to ensure that law enforcement can perform their duties, but Representative Angelos, if you were going to add that kind of language, I would add it wherever that definition of a law-abiding citizen is used, not where the definition is defined, but where that language is used would be a more appropriate place to discuss the activity of that individual, if that makes any sense. So I'm going to be opposed to putting it into the definition as well. All right, any further discussion on the amendment? Representative Sherwood.
Thank you. And I guess I just want to show appreciation for the thoughtfulness of the amendment and the nuance here as we're trying to wordsmith this bill and make sure that our intent is clear. I'm just visualizing that, can any of us really pinpoint the exact moment that a law-abiding citizen becomes a non-law-abiding citizen? Is it in the courtroom when the judge says, here's what I've decided? Is it at the point that the flashing lights turn on behind you and you realize you've done something stupid? I think there's a lot of gray in here in terms of, I'll throw out a scenario here. If I decide I'm gonna go out and have drinks with friends, and I don't know if I've really had too many, whatever, and I sit down in my vehicle and I turn the key on and I sit there and I hold the wheel. Have I crossed the line of non-law abiding? But then somebody's like, hey, maybe this is not a good idea. Get in the back seat. I get in the back seat. Am I law abiding again? Right? There's a lot of gray in this area of when do we cross over from law abiding to borderline making stupid decisions and correcting ourselves with help from friends or a moral compass, or the judge offers us correction. I think we should embrace it. There's a lot of gray in this area. Thank you.
Representative Pendergraft.
Thank you, Mr. Chairman. I would agree with that previous comment that the concept of who or what is law-abiding is pretty much subjective in the eye of whoever's observing the activity. And it begins, in my mind, to get into intent. It gets into an individual's perspective on a particular aspect of society or whatever, where somebody might be predisposed against, I see somebody with a deck of cards in their vehicle and I'm already assuming that they're a bad person, and that's kind of an extreme example, but I can't accept the terminology there.
Okay. Further discussion? Seeing none, all those in favor of the Angelos amendment, say aye. Aye. All those opposed? No. Okay, that is defeated. Okay, we're back on page 8. Page 9.
Mr. Chairman?
Representative Haroldson.
I'd like to, on page 9, line 8, insert that section 3, and Jackie, you'll find that on that original handout I gave you, which is that severability clause, which we all should have that language from yesterday. And for some reason, it did get put into the omnibus amendment, but it is on that first page I handed out yesterday. So it just reads that section 3 would be for that Wyoming statute 914-204, and it's created to read, and then that goes on with the severability clause.
For the public record, Representative Haroldson, go ahead and read the entire clause, please.
Absolutely. It states, if any provision of this act or its application to an individual or circumstance is held invalid, the invalidity does not affect other provisions or applications of this act which can be given effect without the invalid provision or application. And to this end, the provision of this act are severable.
Okay. Any questions on the amendment? Do we have a second on this amendment yet? Don't think I do. Seconded by Smith. All right, any discussion on the amendment? Seeing none, all those in favor of the Haroldson amendment say aye. Aye. All those opposed, no? No. Okay, that carries. Still on page 9. All right, discussion on the bill. Representative Sherwood.
Mr. Chairman, did we correct the language on page 9, line 4, to change not including to include?
Representative Sherwood, we did that in the first Haroldson
okay.
amendment.
Thank you.
It's the very last line. You should have a copy of that. It's page 1 of the amendment, line 30. All right. Thank you for the question. Any further discussion on the bill? Okay, seeing none. Ms. Childers, please take the roll.
Roll call vote, Senate File 196 do pass as amended. Representative Allemand? Aye. Representative Angelos? Aye. Representative Haroldson? Aye. Representative Pendergraft?
Aye.
Representative Sherwood?
No.
Representative Smith?
Aye.
Chairman Bear?
Aye.
Mr. Chairman, 6 aye, 1 no.
Thank you. All right, that's a do pass, and Representative Worf, you've got that for the floor management. I think you probably got some allies on the committee to help you on the floor with that. All right. I am going to probably have Representative Harrelson handle the amendments from the committee. So we'll hand the bill over to you as soon as we get the committee amendment presented. Thank you. All right. All right, we're going to take a few moments here. Got about 7 minutes. I'm willing to get started on Senate File 34. I don't think we're going to finish it, Mr. Comey, but I would like you to present the bill so you don't have to come back here again, and then you can take testimony on the bill at a later time. So if you're here for Senate File 34 to testify on it, we're gonna probably take this up in our next meeting, which Ms. Childress, I guess that would be noon tomorrow.
Thursdays are usually at 8, but we can
Oh,
definitely
Thursday at 8.
switch
Yeah,
to
we are
noon.
off schedule here, sorry.
Yeah.
So 8 a.m., that's why I looked to you to make sure I got that right. So it'll be 8 a.m. tomorrow. We'll take up public testimony on this bill, and appreciate anybody being here for that matter, and apologize we won't get it to you today. Director McComey, welcome to House Appropriations.
Thank you, Mr. Chairman. Dale McComey, State Construction Department. Senate File 34 is a school finance for routine and major maintenance calculations. It was sponsored by your Select Committee on School Facilities after an interim study this past summer. It's an act relating to the K-12 public schools finance, increasing the allowable square footage utilized to calculate both routine and major maintenance for school districts, increasing the percentage utilized to calculate major maintenance payments for school districts, and providing an appropriation and providing for an effective date. Mr. Chairman, there's really two sections to this. The first is noted on line 14, page 1, 21-13-309, and that is the determination of the amount to be included in the foundation program for each district. And this pertains to routine maintenance. On page 2, Mr. Chairman, line 5, that section is based on the ADM calculation also for that routine maintenance. And then down below on line 16G, the amounts within the block grant model for major maintenance and operations shall be based upon the actual gross square footage of school buildings and facilities subject to the following. Line 21, the actual gross square footage of the educational space to be the gross square footage presented by the state building adequacy standards. Mr. Chairman, that's something that we look at in the State Construction Department. And so what this bill does then is it adds in there on the next page 3, pursuant to Wyoming Statute 21-15-115, except as otherwise provided in this section, education space capacity in excess of 115% of the standard space level shall not be included in the actual gross square footage of the computation under this subdivision for school year 2025-2026, educational space capacity in excess of 135% of the standard space level shall not be included in the actual gross square footage computation under this subdivision. So currently, and for the last number of years, we've looked at the 115% of actual square footage being available. So there are some districts that have more than that. There's some districts overall have less square footage than 115. And the intent of what was looked at this past summer was to increase that to 135%. The next section on line 12, or on line 11 of page 3 pertains to major maintenance. And again, that's 21-15-109, major building and facility repair, replacement of pavements, calculation, square footage allowance, and the use of funds, accounting, and reporting requirements. Mr. Chairman, I'll skip ahead. This is pretty much standard language for the next page or so. that is in current statute. And so the amendments to that language would start on page 5, line 4. And it says for school year 2009 through 2010 and each school year thereafter, that would be struck, and it would put in there exception as otherwise provided in this subparagraph for each school year up to 115% and prescribed per student gross square footage for the school year 2025, 2026, up to 135% of the prescribed square footage criteria. The second change in the major maintenance formula, and this was not found under the routine maintenance that we talked about earlier, is a change that can start on line 12 of page 5. It says multiply the amount computed under paragraphs CV of the section for the adjusted square footage of the district's educational calculation to 2.5% for the school year, and then striking out 21, 22, 3% for the school year 22 to 2003, and by the percent 2% for the school year for 2003, 2004, and inserting 2025, 2026 in each school year thereafter. So interestingly, Mr. Chairman, originally when the department came into being, the commission at that point in time in 2003, there was a 2.5% multiplier of your CRV in the calculation for major maintenance. Then that was amended up to 3% that following biennium, and then back down to 2%. And since 2004, we've been at that 2% up through today. And then, of course, this bill was to adjust that up to 2.5%. Finally, Mr. Chairman, if we go over to page 6, line 1 for school year 2001, 2000, we're striking out this language, 2001, 2002, the 3% for school years 2002, 2003, and by 2% for each year from 2003 to 2004, and then we're inserting again back the 2025, 26 in each school year thereafter as adjusted as follows. On line 6, section 2, there is appropriated $38,100,000 for the public school, from the Public School Foundation Program account to the State Construction Department for major maintenance payments to the school districts made necessary by this amendments enacted in section 1 of this act. This appropriation shall be for the period beginning July 1st of 2025 and ending June 30th, 2026. This appropriation shall not be transferred or expended for any other purpose, and any unexpended, unobligated funds remaining from this appropriation shall revert as provided by law on June 30th of 2026. So, Mr. Chairman, as the bill was originally written, and I started off the description here, we were addressing routine maintenance. The funding from on the Senate side took out the funding note in that, and that was about $5 million for that year, and that was taken out. Originally, the bill would also have moved forward major maintenance into the future. The way it was amended and out of the Senate and where it ended up today is that there's a one-time funding of that $38,100,000 for this year only, and in the future, that would not become part of the standard budget as major maintenance typically does. And so any increases in the future would follow the normal process, and we would revert back to the 2%. So with that, Mr. Chairman, I'd be happy to answer any questions.
Okay. Questions for the director? I have a few. Okay. I know you're shocked by that. Representative Haroldson.
Thank you, Mr. Chairman. So looking at this, we're looking at $38,100,000 for a 1 year to kind of bring this major maintenance back up in that conversation. So as we're looking at and just, again, I'm gonna probably show some green behind the ears on this. Can you just kind of give me that high level of, obviously, we see those major maintenance projects coming before us in some of our, well, it was budget, and then we pulled that out, but that conversation. So is this more maintenance in the realm of like snow removal and light bulbs and that type of stuff? Or can you talk to me what this maintenance is and how this 0.5% change affects that?
Director McCombie.
Thank you, Mr. Chairman. Yes, major maintenance is your larger component. What you originally referred to on snow removal, those sort of things, that would fall under routine. And so the major maintenance would be, you know, your roofs, your electrical systems, HVAC, your larger components to a building.
Representative Haroldson.
Thank you, Mr. Chairman. So this is just changing the amount of money that we're putting in for those projects that we would then see coming into the next year's budget, correct?
Mr. Chairman, that's correct,
McCombie.
yes.
Further questions for the director? Representative Pendergraft, we've got 1 minute.
I'll hold that question.
So Director McCombie, I've got some questions, not enough time to ask them. I'm gonna just ask you those offline, but they're gonna have to do with, how did we get this so complicated? You know, why do we have to have anything other than 100% to apply this multiplier to? Because we could change this multiplier based on 100% of square footage, in my opinion. So I'd like to know how we got there. And also, I see 2 increases here, one to the percentage, which looks like 20%, and one to the multiplier, which looks like 25. The 2 combined would be about a 45% increase for one biennium. So I'd like to understand that, and if we could just have that offline, then I'll discuss it during the next meeting. That way you don't have to return. If you'd like to return, happy to have you.
Yep. Mr. Chairman, we're more than happy to return.
All right, then let's just plan on Representative Pendergraft and my questions. We'll deal with those when we return tomorrow morning.
Okay, thank you.
Okay, thank you. We're adjourned.